Hello, everybody. I hope you're doing well. Welcome back. We today are revising 7th chapter of Indian polity, and since fundamental rights is a very huge chapter and it's a cyclopean task to complete it in a day or in a video, this video compiles completely analytic view of Article 13, and after which we will look into the other articles of fundamental right and complete this chapter in a very easy manner that we can. Let's get started and look into what Article 13 has to give to us. Article 13 says that all laws that actually, if put up by the parliament, are inconsistent or derogation or is looked on as not beneficial for the citizens as being the fundamental rights, all those laws shall be void. In other words, it expressively proved for the doctrine of judicial review. What is doctrine of judicial review? We will see when we actually do the Supreme Court and the judicial review, judicial activism and PIL. These are all parts of the Supreme Court chapter. So we'll study when we do that. So this is what this says, that it expressively provides for the doctrine of judicial review, and this power has been conferred on the Supreme Court by Article 32 and the High Court's Article 226. What is this power? This power is when it says that, it was saying here that they are defended and guaranteed by the Supreme Court, so a Greek person can directly go to the Supreme Court, or they can actually, this fundamental rights is enforceable, it is justiciable in this court. All of this is actually conferred by Article 32 for Supreme Court and Article 226 by the High Court. And thus it says that this can be declared null and void. And what see here, the laws that they are mentioning here, what do we actually mean by those laws? What are the laws that comes inside this? See, permanent laws that have been enacted by the parliament or the state legislature, if it is inconsistent or derogation of the fundamental right, it shall be declared void. Then what do we have? We have the temporary laws like ordinances issued by the president of the state governments, then statutory instruments in the nature of delegated legislation like the order, bylaw, rule, regulation, notification, and non-legislative sources of law, that is custom or usage having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right. Also, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged in the court. What does it say? That Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, Supreme Court held in Kesavananda Bharati that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the constitution and hence can be declared as void. We will actually understand what is basic structure, what is judicial review. We actually have to see all of this before getting into this. So, see, what happened during the Article 13 thing that had started, and why were so many disputes arising, like Kesavananda Bharati case. I don't know if you've known about the Golaknath case or the ShankariPrasad case that was there, but we actually have to understand to all of this before getting into the further chapter. See, if you take this page and if I try explaining to you all of those cases, all of those portions, so that we actually get into what Article 13 is finally and what do we actually get to know about the basic structure in the judicial review, I would try to make it very quick and very swift for you. Let's get started. See, there was basic conflict between DP, SP and FR. What was the conflict? See, FR was justiciable. DPSP is non-justiciable. What is DPSP? Directive Principles of State Policy, which we will study when we study the chapter 8 of the Indian polity. So this we'll study that this is non-justiciable in the court. So this is one thing. FR is justiciable, DPSP is not justiciable on the court. And the moral obligation of the state to implement the DPSP. This state wanted. Why? Because DPSP, we will study, acts as a moral value to the citizens. The citizens get to know what are the duties towards the states, whereas fundamental rights is the rights of citizens. So this is more heavier on the citizen side and this is more heavier on the state side. So what happens is, when the justiciability of FR and the non-justiciability of DPSP on one hand was there, and there was a moral obligation of the state to implement DPSP, that is Article 37 that we'll see later, have led to a conflict. It led to a conflict between the two since the commencement of the constitution, or whether what to happen, what not to happen. What was the question? The question was whether FR can be amended by the parliament under Article 368 that we consider, that we've seen, that we've studied. This issue, that whether FR can be amended, this issue actually came for the consideration of the Supreme Court within a year of the constitution. And why did it come? What happened then? See, when we actually see the Article 31, we see that Article 31 was the right to property was deleted from the list of fundamental rights and it is made a legal right. But this Article 31 has been a question in everywhere that we see, and we'll actually see that the very first Amendment Act that happened, the very first Amendment Act that was happening, we'll see what was it. See, it was a lot of amendments that happened, but in this we'll see that there was, see, it provided for the saving of laws providing for acquisition of estates. It was the 9th schedule was added. We actually studied about 9th schedule. What that it protected the land reform and other laws included in it from the judicial review. And what did it do? It added 3 more grounds of restrictions on freedom of speech and expression, that is public order, friendly relations with foreign states, and incitement to an offence. And it made the restrictions reasonable and thus justiciable in nature. So what was happening? These all controversies that were happening in the very first Amendment Act, which took place in 1951, was something that came under consideration for the Supreme Court to know whether FR is justiciable or not, whether FR can be amended or not, and if FR can be amended and if all of these restrictions can be put up, then why did our forefathers initially plan to let FR operate as limitations on the tyranny of the executive and the laws of the legislature? This was the question that arose since the commencement of the Constitution and was the highest, at its highest peak, in the First Amendment Act of 1951. This was the question. Then what happens? See, once when Article 31, once when the right to property was there, right to equality, see, we saw actually in the First Amendment, right to equality was also somehow curtailed. Why? Because all of these were required when the abolition of zamindari had to take place. See, when we had abolition of zamindari, we all know that fundamental rights has given us the right to what? See, in Article 31 we saw that it is right to property. Now if you remove the if you abolish the zamindari system, what is happening? These zamindars who were to collect revenue from the peasants here, what are they getting? If you abolish this, their rights are being derailed, their rights are being curtailed, their rights are being abolished. So what will they do? They will file the case to the Supreme Court as to that their rights have been curtailed. So this was something that actually took place in the very first of the commencement of the Constitution. And what was happening, that abolition of zamindari system that was introduced by British India to distribute land owned by zamindars in large numbers to the landless tenants in direction to achieve DPSP. There were a lot of policies here. So what happened? The government decided that the lands that were all held by the zamindars, that were all under the lease by the zamindars, they will take away some lands from here and then give it to the peasants here, so that there is a lessening of inequality and one of our directive principle can be achieved. Then came ShankariPrasad case. ShankariPrasad case was held in 1951, the same year when the First Amendment Act actually had to take place. So ShankariPrasad case was the cause. What happens? That in ShankariPrasad case, the constitutional validity of the First Amendment Act was challenged. Why? The Supreme Court ruled that the power of Parliament to amend the Constitution under Article 368 also includes the power to amend the fundamental rights. So right now when we say that the Parliament cannot amend, the Supreme Court said that yes, Parliament has the power. So the word law in Article 13, that we had here, it includes what? It includes only ordinary laws and not Constitution and Amendment Acts. Therefore, Parliament can abridge or take away any of the fundamental rights. See, there is no law that says that Parliament can, there is no law that says that constitutional amendment also falls under this Article 13. So, therefore, Parliament can abridge or take away any of the fundamental rights by enacting a CAA, which is Constitutional Amendment Act, and such a law would be void under Article 13. This was the Supreme Court verdict in ShankariPrasad case 1951, which had challenged the existence, the validity of the First Amendment Act 1951. So now what happens? The First Amendment Act as a result was added to the 9th schedule to the Constitution to protect the land reforms laws, which is Article 14 and 31, and then other laws included in it from the judicial review. Now what happens? There was another amendment, Fourth Amendment Act 1955. Now see, what happens in this Fourth Amendment Act 1955? Let's quickly go and look there. See, in the Fourth Amendment Act, we saw that the addition of new laws were there into the 9th schedule. So included some more acts in the 9th schedule, which in these acts, it was authorizing the state to the nationals any trade, matlab, the states, the nationals were authorized to have the any trade in the constitution, which was here. This was what? This was Article 19. Alright, then what happened? In the 17th Amendment Act, there were another 44 laws. See, we'll go to the 17th Amendment Act and we'll see it included 44 more acts in the 9th schedule. So this was something that we need to see right now in order to understand the further case that we'll go through. So what happened was, in the First Amendment Act, 9th schedule was created. Then in the 4th Amendment Act, there were 2 points for the 9th schedule where included some more acts in the 9th schedule, and then there was also 17th Amendment Act where included 44 more acts in the 9th schedule. So this was the 4th Amendment Act, the 17th Amendment Act, and the 9th schedule. So for 4th Amendment Act was there, then 17th Amendment Act came up, which was in 1964, and then all of these were added in the 9th schedule that we have. Then this was 1951 ShankariPrasad case. Then came Golaknath case. Golaknath case was in 1965. What did this case had to say? This case said that Supreme Court in this case reversed its earlier stand. What was the stand that Supreme Court took in ShankariPrasad case? It said that Parliament can abridge or take away any of the fundamental rights by enacting a CAA. This was the verdict given by Supreme Court in ShankariPrasad case 1951. In Golaknath case 1965, Supreme Court reversed its earlier stand, ruled that FR are sacrosanct and transcendental and immutable, and hence Parliament cannot take away or abridge any of the fundamental right. Also, further it also said that one CAA, one Constitutional Amendment Act, is also a law under Article 13, the word that is there within the meaning of Article 13, and hence would be void for violating any of the fundamental right. In other words, the court held that FR can't be amended for implementation of TPSP. So it actually just completely shuffled completely in the opposite direction, gave the verdict in the Golaknath case. Then what happened? After the 4th Amendment Act that was there, 17th Amendment Act that was there up to 1964, and then in 1965 was the Golaknath case, then something again happened. What happened? See, there was 24th Amendment Act. 24th Amendment Act 1971. See, one thing that you actually need to understand is the Constitution has given the Parliament the power to bring in any laws in the Constitution by putting in the amending act. Alright, and the Constitution has given given Judiciary the power to put in their limitation here, to judge their laws, to judge their views, and to act as a protector towards the citizens of India by actually passing on the judgment in the cases. If the citizens have filed any case to the judiciary, they can pass judgments through it and can give an answer to the amendments that was being passed. So we'll see that this loophole that we can say was founded by the Parliament, the government and the judiciary, and thus they were just playing with the amendment and the judiciary case. So we'll see there was initially First Amendment Act, then we had ShankariPrasad case, then there was 4th Amendment Act, then there was 17th Amendment Act, then we had the Golaknath case where it gave an answer to all these amendments. Then what happened? Then we come to the 24th Amendment Act. Let's go and see what happened in the 24th Amendment Act and what do we see there and what made them start with a new thing again. See, in the 24th Amendment Act that we'll see, we find that this act amended Article 13. So what happened in the Golaknath case that we saw, where Supreme Court included in Article 13 whatever it had to, this act amended Article 13 and the Article 368. Now what does this act say? That, see, to affirm the power of Parliament to amend any part of the Constitution, including fundamental rights that we see here. So this Constitutional Amendment Act said that Parliament has the power to abridge or take away any of the fundamental right under Article 368, and such an act won't be a law under Article 13. And this stands even today. This is here, even today. Then what happened? Again, Parliament was not satisfied with this. Parliament went further. See, 25th Amendment Act, it inserted a new Article 31C. This would be here somewhere. See, it curtailed the fundamental right to property. What was? See, Article 31C said what? That no law which seeks to implement the article specified in Article 39B and C shall be void on ground of violation of the rights guaranteed by Articles 14, 19 and 31. This is Article 31C that we talk of, that I was speaking of. This was added by the 25th Amendment Act. So what is this saying? This is
taking this amendment is showcasing that Parliament has the complete power. Parliament says that any law made to give effect to the DPSP contained in Article 39B or C cannot be challenged on the ground of violation of the rights guaranteed by Articles 40. This was something that nobody could endure, that something which our forefathers haven't thought of. And what was Article 39B and C in the DPSP chapter? Let's quickly go and look into it so that we don't have to confuse or assume something on our own, and then let's clear our point over this DPSP 39B and C. Fundamental rights is a very, very big chapter. I don't know how am I going to complete so easily. See, where is Article 39B and C? See, 39A is here, 39B and C. The equitable distribution of material resources of the community for common good and prevention of concentration of wealth and means of production. No, this is 39 here. 39B and C. I don't think it's here. Let it be. Let's quickly come back to our place. See, so we get it that Article 39B and C shall be void on ground. This was here in 25th Amendment Act that the Parliament had passed in the very year 1971. Then what happens? It also passed that no law containing a declaration. Now look into the Parliament. It said that no law containing a declaration for giving effect to such policy shall be questioned in any court on any ground that it does not give effect to such a policy. So this was basically an answer to the golaknath case, that you cannot do any of the things, you are just bounded by us. This was what Parliament meant to say when it told the judiciary about whatever they had to. This is something that judiciary then turned in the Kesavananda Bharati case that we actually saw when we were studying preamble. We came across this case where Supreme Court, who initially in the Berry case had told that preamble is not a part of the constitution, reversed its judgment and told in Kesavananda Bharati case that preamble is a part of the constitution. This is 1971. Supreme Court, what did it do? It overruled its judgment in the Golaknath case. It upheld the validity of the 24th Amendment Act. And stated that Parliament is empowered to abridge or take away any of the fundamental rights. It also upheld the first provision of the Article 31C that was here to be constitutional and valid, but it declared second provision of Article 31C as unconstitutional and invalid on the ground of judicial review. Now we come across the word judicial review. Judicial review is what? Judicial review is a basic feature of the constitution, hence cannot be taken away. See, in basic terms, if we want to see, judicial review is something, are the points or the cases that are here in which the judiciary can review. And if you say that this subject is not a part of judicial review, what happens is, if any citizen, any fellow citizen in this country, if he has or she has any issue with this law that has been passed, and if the Parliament has said that this law is beyond judicial review or this cannot be a part here, then the judiciary cannot do anything here. And this is why judicial review is very important, because this acts as the upheld of the provision that yes, judiciary is a protector of the citizens of India. So what did the Supreme Court say? It declared the second provision invalid, unconstitutional, and said that judicial review is a basic feature of the constitution and hence cannot be taken away. Thus, it laid down a new doctrine of the basic structure of the constitution. From here is what the basic structure comes into the picture. So it ruled out the basic structure of the constitution, and it said that basic structure, these portions that are there in the basic structure, they cannot alter the basic structure of the constitution and everything that comes into it. Thus, after this Kesavananda Bharati case in 1971 came the mini constitution 42nd Amendment Act 1976. In this 42nd Amendment Act, Parliament did what? Parliament reacted to the judiciary's innovative doctrine of the basic structure that it had brought in. What did Parliament do? In this 42nd Amendment Act that was there, Parliament extended the scope of the first provision of the Article 31C, which actually was upheld by the judiciary. Judiciary had accepted 31C's first provision. So what did Parliament do? Parliament extended the scope by including the women and protection and the women's protection, any law to implement any of the DPSP, and not merely Article 39A, B and C, not A, 39B and C would be under 31C. So to clear the confusion, let me just clear. See, in 31C that was here, the article, initially the first provision said that in order to implement 39B and C of the DPSP, Parliament can amend the fundamental rights of Article 14 also, 19 also, 21 also, and nothing comes in between. This was something upheld by the Supreme Court. Now what Parliament did? Parliament said that instead of just 39 B and C, it is any of the DPSP that would be there, and no law can be here to adhere to the DPSP that we actually want to put in. So in other words, the 42nd Amendment Act accorded the position of legal supremacy and primacy to the DPSP over fundamental rights under Article 14, 19 and 31. And what did it do with this? It amended Article 368 and declared that there is no limitation on the constituent power of the Parliament, doctrine of basic structure and nothing, no limitation on the constituent power of the Parliament, and no amendment can be questioned in any court on the ground of the violation of FR. This is what 42nd Amendment Act had brought into as a response to the Kesavananda Bharati case. 42nd Amendment Act was when? It was done in, the Kesavananda was in 1971, 42nd Amendment Act was 1976. So after this 1976 came Minerva Mills case, the response of Supreme Court to the Parliament in this Minerva Mills case that was there in 1980. What happened? The extension, the 31C extension that they said that any of the DPSP can be there, Supreme Court upheld this as unconstitutional and invalid in Minerva Mills case. This was one. Then it invalidated the provision which took away judicial review as it is a basic feature of the Constitution. What was the second thought of 42nd Amendment Act? It said that Article 368 can be amended and nothing comes in between when we have to actually put into any of the DPSP. So this was also something, it was invalidated by the Supreme Court. Why? Because it said that the basic feature of the Constitution is judicial review, and judicial review is a part, so this cannot be taken away. What was the point of judiciary? Judiciary said Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the DPSP. So the war which had started over its very existence, Supreme Court said that our bedrock of the Constitution is a balance between them, not the war between them. And Supreme Court said that they together constitute the core of the commitment to the social revolution that they can bring together. Then they are like two wheels of a chariot and no less than the other. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. So this was something Supreme Court said. It also said that this harmony and balance between the two is an essential feature of the basic structure of the Constitution. Thus, the goal set out by the DPSP has to be achieved without the abrogation of the means provided by the FR. This is what Minerva Mills brought in. So Minerva Mills actually was a response to the 42nd Amendment Act upholding and declaring the unconstitutionality and invalidity of whatever Supreme Court felt was correct, and then Supreme Court fell back to a conclusion of Supreme Court of that fundamental right and DPSP goes together, and it's not versus but it's together. Then what happens? Now what's the present position? See, fundamental rights though enjoy supremacy over DPSP. Why? Because 24th Amendment Act that we were talking of, 24th Amendment Act still exists today, and thus this gives an edge to the fundamental rights. But the Parliament can amend certain fundamental rights for implementation of certain DPSP, but otherwise the basic structure thought existed. So basically it was both the balance between the Parliament's Amendment Acts and the laws made by the the declarations done by the Supreme Court. Now, Article 31 was abolished by the 44th Amendment Act and made a legal right under 300A, which actually we saw. And so long as the amendment does not damage the basic structure of the Constitution, it also includes basic structure, also includes judicial review. Parliament can amend the Constitution for the implementation of DPSP. So, what was basic structure? Basic structure was the supremacy of the Constitution, the democratic, the republic, the unity, the integrity, the freedom, dignity, the separation of power between the legislative, executive and judiciary. So, just one basic example is, if this is a part of basic structure, Parliament cannot put in any of the rules to amend this and any of the laws to amend this and say that no, legislative and executive goes hand in hand or they cannot be separated or anything like that. This is what we call the basic structure of the Constitution that I wanted to explain here. So, this is it with our Article 12 and Article 13. Too much to think of, right? And
I hope you liked today's video. Any doubt, any issue, please follow me on Instagram and get connected there. We'll actually sit together and solve our issue. Thanks for watching. I'll bring up another video very soon.